Representative Zweiner.
Thank you, Chairman. So I guess the first thing I wanted to ask is how much do you expect this bill to cost our counties?
Well, first of all, there's a fiscal note, I think, of $1.4 million, and that would be the grant programs to offset that. And there's a process in the bill to allocate that based on request and based on population of each county. I say of each county under a million in population that choose to participate to offset any costs. I would say that to fully answer your question, there are 3 different programs that if whatever counties that choose to participate and would be required to participate, there is a task model or task force model program. There's the jail enforcement model, and there's a warrant service officer model. Under this bill, no county is required to participate in any one or more. Currently, there are 37 counties that currently participate. Some participate in just one program, some participate in 2, some participate in all 3. But simply the warrant service officer model, I don't know that necessarily requires any particular cost, in that the training for that is generally a one-day on-site training where the ICE trainers or representatives come to that locality and provide that one-day training for those folks. It's a little bit more training. There is some training involved for the jail enforcement model. I'm frankly not sure of the extent of the task model or the task force model training, but that is a little bit more involved. So there could be a little bit more cost involved in that.
Okay, so I want to follow. So there's 3 different modes of 287G requirements. Does this bill require a county to enter into all of those or only one of those? How does that function?
Only one of them. And so if you have a county, and my position is that the county should participate to the extent that they can, but frankly, my bill doesn't require them to. They could participate in the bare minimum warrant service officer model and be within compliance.
And explain to me more what the warrant service officer model
entails. Great question. As I understand it, it grants the power and authority to all the folks that operate a county jail and the officers associated therewith would have the power and authority to serve and execute warrants for immigration violations on designated aliens in those facilities. And so they are trained when it pops up and they show to be have a detainer on them, they would be trained, just a simple training to execute those warrants, notify ICE, and within 48 hours, ICE would need to pick those people up from that facility. So it's a somewhat minimal approach. Some counties have chosen to do that. Some have chosen to do more. And while I'm at it, let me just explain the others. The jail enforcement model is one step above that. It still has the authority to do what the warrant service officer program does, but it also has the power and authority to serve and execute warrants for immigration violations, and they participate in the removal process. So they likewise would notify ICE. ICE again would have 48 hours, but it's a bit more involved than just executing. They have the ability to do that. The one that's more extensive is the task force model, and that is not just conducted in the jail. That would be the power and authority to interrogate persons believed to be aliens as their right to remain in the United States if they are stopped and detained and charged with a separate criminal offense. And so the task force model is more involved, would certainly, I presume, would require more training, and that would be something that would necessarily be conducted. I mean, they still have the same ability that the warrant service model does and the jail model does, but they have the additional authority to properly interrogate someone to determine if they're here illegally and make that determination, which by law they have every right to do that anyway. This would just provide them proper training for doing so.
Okay. Now, my understanding is the training for deputies to participate in the various ICE programs is about $20,000 per deputy. Is that consistent with your understanding?
I have not heard that number from anyone. Again, it depends what program. Now, if you're talking about the task force model, that could be. I don't know. But with regard to the warrant service officer, like I say, that's a simple one-day training. They can get that with multiple people on site in one day. Helps them just be able to properly execute and document the execution of those warrants and notifying ICE. And I can't imagine why that would not only be not $20,000, I can't imagine why it would be $20. I don't think there's any significant cost associated with that. There shouldn't be.
Now, any of these programs would pull our sheriff's deputies away from their current duties, correct?
I wouldn't say that. Usually when you book someone into jail, you go through a diagnostic process. It sometimes takes 30 minutes to an hour when they book people in, and also when they release them. It's not uncommon all they would have to do is check a federal database to see if someone is identified as such. So I can't say that it would take a great deal of time, and therefore I can't see that it would take a great deal of man hours in doing that, because we have people, every jail has people on staff that books people in and releases people in and oversees that constantly.
Yeah, we've had a lot of conversations both in this subcommittee and in the IGA committee itself about the increasing burdens on counties as we see a lot of rapid growth happening in the unincorporated areas. And I think Representative Spiller, my county's no stranger to that. And one of the challenges, among others, has been increased burdens on our sheriff's department to serve areas that are maybe developed as densely as we think of municipalities now. And so what allowances does this legislation make for counties like mine that don't have enough deputies on staff, a county that is sending people out of the county to other jails because we can't keep our jail fully staffed? What allowances does it make for counties like ours that barely have the resources to do the standard law enforcement work?
And and to answer your question, if we're talking about Hayes County, we're talking about someone that's they would certainly be. Now, what's the population of Hayes County?
It was 240,000 as of last
so
census, but we're nearing 300.
They would be required to participate. They can participate in one or two or three of those models. They could do the bare minimum if they want to, but nonetheless, they would be eligible to apply for the grant process to go through to assist with any outside costs other than their normal operations. They would have the ability to do that. So I think, as far as costs, quite frankly, is that the only issue with this bill that has to do with costs, in all fairness, would be those counties that would be over $1 million, because the ones over 1 million in population, the counties that are over 1 million in population under this bill would not be eligible for the grant funding to offset that 1.4 million. So that is, they would have to absorb that cost. But then again, it was designed that way because most of those folks already have processes and procedures built in place in their bookend processes in their jails to identify people and to do that. They would just have to be required to look into the database, see if someone is identified, and then to report that to ICE and then cooperate with ICE in that regard. So they wouldn't be required under that warrant service model to transport. Transportation would be under the jail enforcement model. But as far as just the warrant service officer model, that should not be I couldn't imagine why it would be any cost, much less a significant cost.
Well, Chairman, I think what I'm trying to understand, and I know we represent very different districts, very different communities, and
Sure.
In Hayes County, we built a new jail that is not operating at capacity because we don't have the staff for it. Right. And because of that, Hayes County is sending jail inmates to other counties to be able to be incarcerated until their court date. And so even if, assuming no additional deputy time, which I don't think is quite accurate, but even assuming that, just holding people for that extra 48 hours means we're taking other people who are awaiting their day in court and moving them to another county to sit in another jail at a really high cost. And so I guess I'm curious, have you thought about the way these limited resources that aren't just funds, sometimes it's people, hiring in these high growth areas can be incredibly challenging, incredibly competitive. Have you thought about, whether or not to create an escape hatch for communities like that, or the challenges some of these communities might have meeting these needs, and what other duties of law enforcement that's going to take away from?
No, that's a fair concern, and I'm always concerned with cost. I truly am.
And I want to be really clear. I'm not just talking cost. I'm talking literally not having enough human beings. I don't know how much money you'd have to throw out of Hays County for us to hire 10% more deputies or something.
Right, and by cost, I also mean FTEs, manpower, that type of thing. To the extent that relates to cost, to operate a jail at less than capacity is nothing new. I would say, in fact, most jails throughout the state probably operate at less capacity, not because they don't have the people to house, but because they don't have the full manpower. They're not fully staffed, and that's not uncommon. But I do think, again, there's not a requirement. It's not staggered in this bill that counties with a certain population have to opt into one model versus another. They can opt in at the very minimal amount and should be minimal cost, if any cost. And as I say, when you have people on staff that handle bookends, if someone, again, if you take the warrant service model program and they opt in and choose to do that, number one, it doesn't affect what happens on the street. It doesn't affect officers determining, although we have every right to do that in Texas. It's authorized under Texas. It's authorized under federal law, but it's not mandated. That's a different bill. But it's not mandated. But it does say that, that these people aren't, there's no determination made. They're just brought to the jail for bookend. What this would require the bookend officers to do would be to identify those folks that may be here in the country illegally if they're brought in on a separate charge. So to require that, I don't think is costing more manpower hours. I don't think they're having to add additional personnel to do that, and I certainly don't think there's an additional cost associated with that.
Well, the difference, if I'm wrong, unless I'm wrong, is that somebody who might be bonded out same day might now be on a multiple day ICE hold, correct? So there's a different number of resources for number of people housed at the jail.
Run that by me one more time, I'm
So
sorry.
if a law enforcement officer brings somebody in who's been arrested, if that person does not have an ICE hold on them normally, regardless of their documentation status, that person would potentially be able to bond out
They're eligible for
fairly
bonding,
quickly, depending on the circumstances and the type of crime.
Correct.
But if somebody was in a warrant services agreement, 287G, they're committing to keeping that person there. I believe you said at least 48 hours.
Up to 48 hours.
So
And ICE, and under this, brings up a great point. Under this bill, if ICE does not pick them up within 48 hours, then they're eligible to be released. They could frankly be released on their own personal recognizance, or they could bond out, whatever. That's up to the sheriff, unless you're in a bail bond board county, it's a different situation. But they're eligible to be released if ICE doesn't pick them up within 48 hours.
So if there are additional people being housed in the jail because of this program, that is additional resources from the county, correct?
To the extent that you could have someone that there could be a lapse from the time that ICE is notified and 48 hours later, if they're not picked up, to the extent that those people are there and would be there, yes. But currently, that's nothing new. Most, right now, even without participation in a 287G program, most counties are really supposed to, and I think if you'll talk to many of these counties and the sheriffs in these other jails, they're currently doing this now, at least under this, what's required under this warrant service model. They're doing that now. They pick up someone and they're checking on their own. They determine if they have an ICE hold. If they have an ICE hold, they contact ICE, and ICE is supposed to pick them up. I thought under that statute it's 72 hours, but nonetheless, between either 48 or 72 hours that they have to be picked up, and if not, then that ICE hold goes away and they can do with them whatever they need to.
Well, if they're already doing it, can we just put this bill bill aside and move on for
Well,
the
if they're
day?
already doing it, then they shouldn't have any problem with participating, but that's a fair question.
It was worth a try. Chairman, you've been answering a lot of my questions by talking about the lowest level, the warrant services type of 287G. So I think one of my concerns about this legislation is whether or not it's giving the federal government very different power to be able to negotiate with these local sheriffs. And so what happens if we pass legislation like this and the federal government removes the warrant services option and maybe the jail enforcement option and says, we just want everyone to agree to task forces?
That's a fair question, but I think when they offer these MOUs, memorandums of understanding with the sheriffs, and they sign on to it, they are signing on to participate in exactly the program that they applied to do. If they applied for the minimum, then the warrant service officer model, then that is what they're required to do. If they do away with that, then they're no longer obligated under that process.
Now, is that clear in this language? Because our language doesn't seem to, as currently written, it just says there must be into
But you can
enter into
apply-
a winter.
Yeah,
enter
under the
into
bill,
a
you can
written
apply to
agreement.
whichever of those that you want to do, and that would be the agreement that, and I haven't frankly read one of these agreements. I haven't gotten a copy of it to read it, but generally, my understanding from talking with others that are participating is it's designated which program that you apply for. That would be the program that you agree to participate in, and would have those terms and conditions, that are set forth under 287G of 11 USC.
So as the bill's currently written, there's not a protection if the federal government changes their interpretation of 287G to require more.
I wouldn't say
than what's
that. I
currently
think,
being offered.
they're going to agree to participate in whatever they apply to do. They're not required to do one of these other programs. So the agreement is not going to require them, therefore, to do these. They only agree to what they apply to do, and as long as they're participating under that limited format, that's fine. That program has been in effect ever since the creation of 287G, and I can't imagine them, to require that is a different, at the federal level, is a completely different process. So I can only speak to, and the law as it currently exists.
Yeah, well,
And I will say this, there's grant funding available other than the enforcement by the Attorney General to seek equitable relief, whatever that looks like. I think certainly people have all their defenses. They're entitled to their day in court. If something's been done improperly or the agreement at the federal level or something's been changed, I think those are things that can be addressed in a court of competent jurisdiction.
and to be clear, Chairman, my concern isn't people who've already entered into agreements. My question is if this says Hays County, because my county's not currently participating, under Republican sheriff leadership, but for the record, because of resource concerns, I think primarily. If my county was forced to join one of these by this bill, which I presume does not go into effect until September 1st,
Correct.
the end of this year, if the federal government was to say, oh, hey, we've twisted the 287G program a little bit, now these are your options. Now your option is task force or jail enforcement. As I read your bill as it's currently written, it's really putting all of that negotiating strength in the federal government's hand and giving our locals very little space to push back.
Yeah, I would have to look at the 287G statute and look at this, but to the extent that could create a problem, I'm happy to look at any modifications that might need to be made to address that concern.
Okay, well, thank you, I appreciate that.
Yeah.
The bill also states that sheriffs must allocate the necessary resources to ensure implementation of the agreement. What does that look like?
Well, again, I think it depends what model that you apply under. If you apply under the warrant service thing, I can't imagine there are additional people and resources that you would have to do. Some of these other resources that we're talking about are those that opt in to a different model. Not so much the jail enforcement. I don't know that you would actually have to have that much more to do that as well. But except as far as transportation, if and to the extent that they're cooperating with ICE and transporting people within that 48 hours when they're identified, and the jail opts in and does the transportation, that's a different story. So you could have that cost if you choose to participate under that program. The task force model is a different matter because it's a question of, are you just training your existing officers to how to properly inquire as to someone's immigration status if they're stopped, detained, charged with a separate criminal offense, or are you adding officers? If you're adding officers, yes, there's additional cost, but this program doesn't require anyone to add additional officers. That decision's made at the local level if they choose to do so.
So the language says they must allocate adequate resources. What happens if they don't? What's the enforcement mechanism of this bill?
Well, I think either they either participate or they don't. If there are additional costs, now any additional costs are those to the extent that there are grant funds available. If they qualify for the grant funds and receive those, they certainly they have to document what they did and how they did it and what those funds were used for. But to the extent that there are other costs, if they choose to incur other costs, those are the county's costs. But as I said, I don't think they're going to be significant if at all, especially if they choose to operate and choose to apply for the warrant service officer model, and really even the jail enforcement model, other than the training. Now, the training, let me back up and to answer your question. The training for currently, as I understand it, for the jail enforcement model is you have limited people that you would send, but there would be people that would be trained to do this from your county, from your jail, from the sheriff's department. And there's a training facility. It's a 4-week training course in South Carolina conducted by ICE. Different completely than we come to you and we do training on the warrant service in one day at your location. So yes, obviously, if you have to send someone to South Carolina and train them for 4 weeks, there would be some cost associated with that.
So I think the concern I have about that language, about the county being required to allocate necessary resources, is it looks to me like the enforcement is by the Attorney General. And there's this language in
Right.
At the end of Section 1 of the bill on page 5 that says the Attorney General may bring an action against a sheriff who fails to comply with this subchapter. And that doesn't appear to me limited to did they enter an agreement or not, or did they spend the funds or not. That, to me, potentially creates a situation where some of our counties could end up as political footballs in court arguing over what is allocating adequate resources.
Right. And I don't know if that's a question, but I'm going to try to,
but I mean, I guess
assuming it is, I'm going to try to answer it.
Yes, the question is, how would you respond to that
Right.
concern?
It just says that the Attorney General can bring an action in a district court for appropriate equitable relief. The question is, what is that? Well, what it doesn't appear to be is that there aren't any fines or penalties in that regard. It could, as I could conceive that they could do seek a judicial order compelling participation. They could, you could, there's other variations of this bill that have more punitive actions. If someone doesn't participate, that's not included in this bill. So the idea that someone would be cut off from other grant funding is not included in this bill. The idea that someone or a county could have their sales tax revenues from the comptroller's office withheld is not in this bill. So aside from the Attorney General seeking equitable relief, I don't know what other remedies, other than the cost, they could recover their attorney's fees and cost and other court costs. But other than that, I'm not really sure what teeth, and I'm not inviting anyone to violate this, but I'll put it this way, I've seen stricter enforcement language in bills than what we have in this one.
No, and that's fair. I think my concern, in terms of like structure of enforcement, the ability to say, did you or did you not enter into this agreement feels pretty straightforward and like a pretty easy question to answer from a fact perspective. The question of allocating necessary resources raises a few more red flags for me because of that question of where are we taking folks away from. So I apologize, this isn't really a question, but more of a request for us to continue to think about that.
I'm happy to look at it,
piece of the
but
language.
again, I don't, if someone chooses to opt in, and for example, you could have Harris County, and Harris County, I think they would tell you that, look, we're pretty much doing this already. And if they apply and say, we're going to do the warrant service officer program, if they're doing that anyway, it's not going to cost them anything additionally to implement this program, other than just the time to file the annual or however often it is, just the report showing that we have complied and we are complying.
Okay. One other question is how do you think the state should measure the success of this if we implement it?
Well, I mean, we have compliance measures. When you talk about the success of this, I don't know that we're measuring the success of this other than that we're just, what this bill does, I'm asking law enforcement, local law enforcement, county law enforcement, to do their jobs. I'm asking them to enforce the law. I'm asking them to cooperate with the federal government with regard to the enforcement of federal immigration law, and to the extent that they're allowed to do so under existing state law. I don't think what I'm asking is unreasonable, and I think that every law enforcement agency ought to cooperate to try to enforce the laws that we have. The laws that, I mean, these people that are in the database that we're executing these warrants are existing warrants in the system for which we should be executing and processing those people anyway. So I don't know that I have a success measure other than the fact that I'm just asking law enforcement to do the jobs that they took the oath to do and to uphold the law, constitutional laws of the state of Texas and the United States. That's the oath that they took, and that's what I'm asking them to do, and I don't think it's unreasonable to ask that.
I think what I'm trying to understand is, I think the goals of these programs get usually put in terms of public safety. And I have questions about whether this actually leads to improved public safety. I have questions about whether this ends up turning into some people being more afraid to report crime or serve as witnesses for crime, as well as fears about what this pulls law enforcement away from. As I mentioned, my county is paying deputies more, paying jailers more, trying to hire more, and is still understaffed. So how are we going to measure the success of this legislation or similar legislation if it moves forward in actually addressing public safety concerns?
Well, I think from the federal level, President Trump and Border Czar Tom Homan have made it very clear that we have got to do something to protect and provide for public safety for our nation, and I think we need to do the same for the state of Texas. And there have been countless people, many of which we haven't even documented, that have come across our border, quite frankly, and it's not just the last 4 years, but especially the last 4 years, that we know pose a public safety threat, whether they be terrorists, whether they be convicted felons, whether they be murderers, rapists, child molesters, drug dealers, human traffickers. We know that has happened, and it's happened at a rate that our country has never seen. This bill helps address that problem because, quite frankly, and the purpose of the bill is because at the federal level, President Trump and his administration cannot, in my view, without the help of this 287G bill, cannot assemble the processes necessary screen those folks, hire those folks, train those folks, provide them with the resources necessary to do their job. They cannot do that effectively in the first year and a half to 2 years of his administration without the cooperation of local law enforcement in the state of Texas, period. They can't do it without that. And that's why, in my view, this bill is so necessary, because we have to, as a public safety concern, and what we need for the citizens of the state of Texas to help keep us safer and make us safer than what we are right now sitting here today, we need this bill, in my view. And you may differ, and I respect that, but I feel very strongly about that, and that is the information that I'm receiving, and that's why I think it's so important. And in doing so, again, I'm not asking law enforcement to do anything that they wouldn't otherwise be doing or should be doing, is cooperating with federal authorities, just like we have been, and as we have been over the past 4 years with Border Patrol and so forth, and through Operation Lone Star and so forth, to cooperate with our federal partners. This is just one component of that.
So I appreciate that. And I think what I'm trying to wrap my head around is what those public safety metrics look like. We've, this is not a hearing on Operation Lone Star, but we've seen squishy data with Operation Lone Star, where, traffic-based stops that turned up cannabis in North Texas got reported as Operation Lone Star metrics. And, coming back to Hays County, we do not have a 287G agreement in place, but our sheriff participated and publicly defended his participation in a large raid in cooperation with the FBI and ICE and DPS just in the last couple weeks, in which 47 people ended up in ICE custody, most of them allegedly members of the Train de Aragua gang. And he did all that without a 287G agreement. And I think most of our counties I shouldn't even say most, I think all of our counties are going to aggressively go after the terrorists, the drug dealers, the people that are bringing, or mixing fentanyl in our country. Everybody who is dangerous, I think our county sheriff departments are going after enthusiastically. Regardless of their documentation status, whether they're citizens or whether they're here without papers. What I worry is that this becomes, the person who has an expired driver's license gets a ticket for it, or no driver's license gets that ticket, doesn't pay the ticket because they're scared. They get pulled over rolling through a stop sign, and then, a father of 5 who's run a local stone working business for 20 years in Hays County almost ends up deported. And to be clear, that's not a hypothetical. That's a story that did happen in Hays County. And so how do we measure that we're actually, how under this legislation, if we move forward, do we measure that we are actually improving capturing dangerous people versus folks who have been part of our community sometimes for decades and productive members of our community?
All right. And so this bill is not one of other bills that requires people to determine someone's immigration status and so forth. It's not about that. This, for the most part, if they opt in under the warrant service model or the jail enforcement model, all they are doing is checking an existing database to determine if the person that they have is the person that is already in the database, already has an ICE warrant for violations that would subject them to removal and deportation from the United States under 8 U.S.C. 1227. That's what this bill does. And so we're not getting people for driver's license violations. Those people are not in that database. It's these people that are public safety threats are the ones that are in this database. And that's what we're focusing on here. That's what this bill focuses on. It's not, again, about rounding up other folks that might be here illegally. That's not what this is about. We're talking about executing warrants that are already in the federal system. So, and we have to be able to identify these people, and it just requires jails to identify these folks. And to the extent that Sheriff's Department participates in this program, they either participated at a minimal level, an intermediate level, or if they want to participate at a much stronger level, they have the option to do that.
What are the different ways somebody can end up with an ICE warrant?
I couldn't tell you all of that. I don't know. Certainly, if they would otherwise be picked up, if they went through if they got here into our country and in our state and arrived legally through a actual port of entry, they would be the people that would be picked up, or they're people that have been identified and released someplace else that are subject to being picked up again, or they violated their parole. They violated their parole not in the state system but in the federal system. There are a number of things I think that would qualify for someone to be in that system. But again, the federal government, they have due process to involve. We're not going to remove people that shouldn't be removed or which legally they don't have the authority to remove them. I have, for the most part, I think they go through that process. This is just identifying the people that end up in our county jails and turning them over to ICE to let ICE process them the way that they should under existing federal law.
So, Chairman, correct me if I'm wrong, but my understanding is ICE warrants generally have nothing to do with somebody's criminal history outside being in the country without documentation.
I can't speak to that. I think there's any number of things that could trigger an ICE warrant under our existing law.
But
now,
that could be not showing up to an immigration status hearing, correct?
I don't know about that. I don't know. But certainly if someone has violated, that may put a hold on it. I don't know if that is, I don't know that that's one of the reasons for a warrant that would be issued. I can't answer that, but I can check into that and let you know.
Thank you.